This is Barry Zelma speaking for Claim School Incorporated, Zelma on Insurance blog. Today I'd like to speak about how, when an insured intends to harm someone, that caused harm is not insurable, and especially when the insured beats an employee about the head, body, legs, with a pistol for 4 hours, that event must be excluded. State Farm Fire and Casualty Company filed a motion for summary judgment, arguing that it owed no duty to defend or indemnify the defendants Hamdallah, L.L.C. et al., the LLCs, against the claims asserted by plaintiff Nixon Calix. The trial court granted summary judgment and dismissed all the claims against State Farm in a case called Nixon R. Calix versus Ideal Market No. 6, Hamdallah, LLC, Kaki and Son, LLC, Mario Kaki, and many others, filed in the Court of Appeal for the Fifth Circuit of Louisiana. The court explained the right to rely on a clear and unambiguous exclusion. On May 28, 2015, Nixon Calix sued for damages against Ideal Market No. 6 and the others, alleging that while employed at Ideal Market No. 6, he was assaulted and battered by fellow employees who also threatened his life. According to the facts alleged, Mr. Calix was an employee in the meat department at Ideal Market No. 6, where Mario Kaki, Mohammed Kaki, and Muwafak Kaki were also employed in managerial capacities. Mohammed Kaki and Cory Elbarqa transported Mr. Calix to a location on L.N.A. Road. There, Mr. Calix was accused of stealing meat from Ideal Market No. 6 and was subjected to a violent physical assault and or a battery by Mario Kaki, Mohammed Kaki, Cory Elbarqa. Mario Kaki brandished a firearm, pointed it at Mr. Calix, and threatened to kill him if he did not confess to the alleged theft. When Calix refused to confess, Mario Kaki used the firearm, as well as his fists and legs, to beat Mr. Calix's head, face, and body for approximately 4 hours. Mr. Calix claimed that he was severely beaten, punched, kicked, abused, and terrorized by Mario Kaki, while Mohammed Kaki and Cory Elbarqa watched and prevented him from leaving. As a result, Mr. Calix alleged he suffered severe mental and physical injuries. Mr. Calix alleged his injuries were caused by the intentional acts of the defendant: assault, battery, kidnapping, false imprisonment, and intentional infliction of emotional distress. Additionally, Mr. Calix claimed that the LLCs were vicariously liable under the doctrine of respondeat superior for the derivative liability of negligence and fault of its employees, and were liable individually, jointly, severally, and in solido through their own negligence, specifically for negligent hiring, negligent training, negligent supervision, and negligent retention, in an attempt to get into the deep pockets of the insurance company, State Farm. State Farm filed a motion for summary judgment, alleging there's no coverage under its policies for the claims against the defendants. The trial court signed a written judgment granting the motion for summary judgment and dismissing all of Mr. Calix's claims against State Farm with prejudice. The trial court found that regardless of the legal theory argued by Mr. Calix, the intentional actions of the owners, managers of the defendant companies, in particular the actions of Mario Kaki, are the essential cause of Mr. Calix's alleged damages. Coverage for these actions was specifically excluded by the policies. A dispute as to the issue of whether, as a matter of law, the language of an insurance policy provides coverage to a party can properly be resolved within the context of a motion for summary judgment. The extent of coverage is determined by the party's intent, as reflected by the words of the policy. An insurance company may limit coverage in any manner as long as the limitations do not conflict with statutory provisions or public policy. Mr. Calix argued that the expected or intended injury exclusion does not apply to preclude vicarious liability or liability premised on respondeat superior. Finally, he contended that the State Farm failed to meet its burden in its second motion for summary judgment because his injuries arose out of negligent hiring, training, supervision, or retention over multiple employees of multiple employers and not a single action of one person. The State Farm policies contained an exclusion for expected or intended injury which provided, quote, bodily injury or property damage expected or intended to cause harm as would be expected by a reasonable person, or bodily injury or property damage which was the result of willful and malicious or criminal acts of the insured. This clause does not, by its precise terms, exclude coverage for bodily injury caused by the insured's intentional acts. Rather, it excludes coverage for bodily injury expected or intended from the standpoint of the insured. The phrase bodily injury, which is expected or intended, emphasizes that an excluded injury is one which the insured intended, not one which the insured caused, however intentional the injury-producing act. The next phrase, quote, from the standpoint of the insured, close quote, emphasizes again that it is the insured's subjective intention and expectation which delimit the scope of the exclusion. The Court of Appeal concluded that reasonable minds could not disagree that accepting the allegations is true. And Mario Kaki's testimony and Mr. Calix's testimony established that. Mario Kaki's actions of using a firearm as well as his fists and legs to beat Mr. Calix's head, face, and body for approximately 4 hours were expected or intended to cause bodily injury. Accordingly, there was no error in the trial court's finding that the policies exclude coverage of any liability imposed on any defendants arising from Mr. Calix's claims of assault, battery, kidnapping, false imprisonment, and or intentional infliction of emotional distress alleged against Mario Kaki, Mohammed Kaki, Muwafak Kaki, and Cory Elbarqa. The trial court correctly pointed out in its judgment, even if defendants' actions were deemed to be negligent, any liability imposed on the defendants arising from their alleged actions are excluded from coverage based on bodily injury to a co-employee, and at best he can collect workers' compensation. Having found that the policies excluded coverage for the intentional acts of the employees and managers, the Court of Appeal also concluded the policies do not provide coverage to the LLCs for any vicarious liability based on the employees' actions. Any claims that the LLCs are liable based on claims of negligent hiring, negligent training, negligent supervision, and negligent retention stem from or are dependent on Mario Kaki's actions. Therefore, there was no coverage under the present insurance policies based on allegations of negligence for damages resulting from Mario Kaki's intentional acts, and the trial court's decision was affirmed. In my opinion, fortunately for State Farm, its exclusions clearly fit the allegations of the suit and the facts developed by the deposition of the plaintiff. No insurer should be required to defend or indemnify a party. Insured who beats the plaintiff with fists, feet, and a pistol for 4 hours. A clear felony. A single punch might be accidental, but 4 hours is nothing more than a vicious beating that intentionally caused injury to the plaintiff, and he's only lucky that it didn't kill him. Mario Kaki and his cohorts will be required to defend themselves and pay any judgment the plaintiff obtains without the benefit of insurance. This video was adapted from my blog, Zalma on Insurance, which is available at www.zalma.com/blog. Thank you for your attention.